Good afternoon, everybody. Thank you for joining us. We are giving everybody just a few seconds to log in and connect and start viewing us before we get started. We are streaming this to multiple places today. So if you are wanting to ask questions of our speakers once we get going, you can put them in the comment in whichever platform it is that you are watching from. And we will do our best to get to all of them, but I can't guarantee that we will be able to. Depends on how many really great questions we have. And based on conversations happening elsewhere on the internet, I think we're going to have a ton of questions. So we will do the best we can. If we don't get to all of them, we apologize, but we will try very, very hard. So we'll just give it another minute for folks to join in. All right, those numbers look like they're evening off. So thank you again for joining us this afternoon. We're going to be talking about understanding Espinoza, driving a school bus through church-state separation. And with us this afternoon, we have some wonderful speakers and presenters. And our first one is Alison Gill, who is American Atheists Vice President for Legal and Policy, where she manages the organization's federal and state advocacy for religious equality and litigation activities to protect the separation of religion and government. Alison is a nationally recognized expert on civil rights and law and state advocacy. Thank you, Alison, for joining us today. Then we have Andrew Seidel, who is a constitutional and civil rights attorney, author, and former Grand Canyon tour guide. At the Freedom from Religion Foundation, Seidel works to ensure the government obeys the First Amendment and that Jefferson's wall of separation between state and church remains tall and impregnable. He's appeared on MSNBC, Fox News, and countless local news stations, and has written for a whole host of news outlets, as well as his own books, which I'm sure most of you have heard of his book that he's been talking about on our program. And then last, we have Nick Little, who is the Center for Inquiry's legal director, handling both CFI's internal and external legal work. Recently, he's been focusing on ensuring representation for the secular community in multiple Supreme Court amicus briefs, advancing the ability of secular celebrants to perform marriages in multiple states across the country, and litigation CFI's consumer protection lawsuits against Walmart and CVS for those stores' marketing of homeopathic products. So with that, I am going to turn it over to our speakers. And just a reminder that you can ask us any questions that you would like in the chat of whichever platform that you are watching us on, and we will get to them after our presentation. Thank you. Andrew, you're muted.
And there we go. I was clicking the button and it wasn't unmuting. So, all right, can everybody hear me now? Okay. Okay, so I'm going to speak first, and I'm going to do a little bit of the setup for this case so everybody is on the same page with what was happening in this case. And then Alison is going to explain what the court did, and then Nick's going to talk about the impact of that, and then we're all going to do questions and answers and commiserate together. So Montana is one of 38 states that has a no aid clause in its state constitution. And the no aid clause says that Montana, quote, shall not make any direct or indirect appropriation or payment from any public funds or monies or any grant of lands or other property for any sectarian purpose. That's Article 10, Section 6. It sometimes is mislabeled as a Blaine Amendment. This is a name that is meant to paint the provision as anti-Catholic. The federal Blaine Amendment would have amended the U.S. Constitution to include one of these explicit no aid clauses. That was proposed in 1876. when 17 states out of the 37 or 38, depending on when in 1876 you're talking about, already had these provisions. These provisions date back to the founding and before. So, for instance, New Jersey's state constitution has a no aid clause that was put there in 1776. Another 21 states added no aid provisions after the federal Blaine Amendment. And they vary in terms of their language. 29, I think, have it pretty strictly as no compelled support for a religion or the like. But again, these no aid clauses represent a founding American value, right? It's something that dates back to the beginning of our republic. And but the basic idea behind them is that no individual should be taxed in a way that violates their freedom of conscience. So the government doesn't have the power to take your money and then give it to a church that is not your own. Put another way, all tithes have to be voluntary. The government can't enforce them. Think of it like that. So this case involves that no aid clause in Montana's state constitution. So Montana passed a neo-voucher program. We call it a neo-voucher because this is a way to funnel public money to private schools. And the way their neo-voucher was set up, it was a dollar for dollar tax credit. So the taxpayer would donate money to this student scholarship organization, all of which were religious, and then would get a dollar for dollar tax credit for it. So here's the way it works. A taxpayer in Montana owes the state money, right? Taxes, they're a bummer. And instead of paying the state, Montana said that you, taxpayer, can divert that debt to this entity, this scholarship fund, that funds religious education. And then the state would forgive the debt. So Montana appropriated $3 million to cover the anticipated shortfall from forgiving those debts. So, but for the debt that the taxpayer owes to the state, the debt that is to be forgiven and which exists only because of how Montana is manipulating its taxing power, this neo-voucher program would not exist. So without the state, anyone could donate to sectarian school or the scholarship program, but Montana was deliberately incentivizing that donation. Okay. Now, remember that no aid language in the Montana Constitution. Though the text is clear, it's emphatic and it's sweeping, right? Montana shall not make any direct or indirect appropriation or payment from any public funds or money or any grant of land or other property for any sectarian purpose, right? It's really, really broad and clear language. And the Montana Supreme Court found that neo-voucher program fell under the ambit of the no aid clause and struck it down. And it's really important to understand that the Montana Supreme Court didn't just strike the program down as it applied to religious schools, even though more than 95% of the schools that were receiving these neo-vouchers were religious. The court struck the entire program down. It said all of this has to go. And the entire program has to go. And part of the reason for that is because when the Montana Constitutional Convention got together, they wanted to support public education in general. That was one of the reasons they included this no aid clause. So they said that part of the purpose of that no aid clause was to, quote, ensure that the public school system received unequivocal support. Unequivocal support. So they didn't want to fund, so here, let me read it again. Any diversion of funds or effort from the public school system would weaken that system in favor of schools established for private or religious purposes. So they struck down the voucher program entirely, not just as it applied to religious schools, but as it applied to private and religious schools. So FFRF, AA, American Atheists, Center for Inquiry, and American Humanist Association, we all submitted an amicus brief in this case to the court. And I'm just going to talk a little bit about our central argument there. What we wanted to do was talk about the true religious liberty right at issue here, because no aid principles are vital to ensure true religious freedom. Religious liberty cannot exist when the government can force citizens to donate to a sect that promises them, for example, eternal torture if you exercise that religious freedom. Right? So the compulsory support of a religion or a God that is not your own is anathema to American principles. And that is really what we wanted to focus on in our brief. We wanted to point out that the religious liberty, the religious freedom at issue here did not lie with the Montana parents and Christians in this case, right? It actually lay with every single Montana taxpayer. Every single one had a religious freedom right not to be taxed and then have that money go to churches, whether or not it is direct or an indirect tax. Okay, that violates the deepest freedom of conscience of every single citizen. We did a lot of quoting from founding documents in our brief. Thomas Jefferson said that wielding that taxing power in that way was both sinful and tyrannical. Quote, sinful and tyrannical. We came back to that a bunch of times. James Madison as well. These are the sort of original thinkers and writers when it comes to this principle. So that was really where our brief focused. We wanted to show that there is a religious freedom, that religious freedom is imperiled in this case, but that the right doesn't lie with those parents. It lies with every single Montana taxpayer, regardless of their religious liberty, their religious belief. Okay, so that's the setup for the case. That is the argument that we tried to make. And one other thing we need to do before we jump in and Alison explains it is recap an earlier case called Trinity Lutheran from 3 years ago, because that plays a big role in what we're going to talk about today. So in 2012, Trinity Lutheran is a church in Missouri, applied for a grant that the state was administering to replace a gravel playground, those pea gravel playgrounds, surface with rubber. And Missouri had this program allowing playgrounds to upgrade using recycled tires. Missouri also had a no aid clause. It said that no money shall ever be taken from the public treasury, directly or indirectly, to aid any church, something along those lines. Okay, so Trinity Lutheran sued Missouri because it said, you're denying us the ability to participate in this program. And they said that violates their free exercise rights. And that was the same challenge that you had in Montana from those parents. Okay, so the fascinating thing about this is that before the Supreme Court decided this case, a newly elected Missouri governor changed the state's policy and ordered the state to include churches in, or allow churches to apply for those grants. And that should have actually killed the case because all the parties agreed. There was no adversity. Right? In our system, there has to be two adverse parties arguing over what the law says and what the facts are. And you didn't have that in Trinity Lutheran. You had two parties agreeing about what the law said and agreeing about how things should happen. That should never have been decided by the Supreme Court. And it certainly wouldn't have been if that had happened in one of our cases, ours being the secular movement here. So if you ever talk about Trinity Lutheran, that has to be part of the conversation. The court had no business deciding this. But anyway, what Roberts ended up saying in that case was that, quote, the exclusion of Trinity Lutheran from a public benefit for which it otherwise qualified solely because it is a church is odious to our Constitution and cannot stand. And there was a footnote, sort of an infamous or famous footnote 3, that in Trinity Lutheran that really did seem to limit the decision to just playgrounds. But everybody who's going to be talking to you today, we all saw the other shoe dropping. And Alison is now going to discuss how that shoe hit on Tuesday in the Espinoza decision. So Alison, go ahead and take it away.
Thanks so much, Andrew, for laying the groundwork there. So this is a complex case. There is one court opinion and 3 concurrences and 3 dissents. I'm going to focus on the court's opinion written by Chief Justice Roberts, and I'll touch on the concurrence and dissents if I have time. We'll see how quickly I can get through it all. The case was decided on a 5-4 on its primary question of, does the free exercise clause of the Constitution prohibit the application of a no aid clause to prevent state funding from being provided to religious schools? And under this decision, the answer is yes. Can you put up quote number 1, please? So The quote is, "A state need not subsidize private religion, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious." And so this is a pretty key part of the holding of the case. So he's saying that the state does not have to pass these programs in the first place, but if they do create them, they cannot exclude religious schools. They have to include religious schools. So let's explore why that is so. You can take it down. First, Chief Justice Roberts first clarifies that the tax program is allowable under the Establishment Clause. Just to clarify, this was not actually a contention in the case. No one argued this was not allowable under the Establishment Clause. But in fact, he characterizes previous decisions in this area very widely to say that the Establishment Clause is not implicated by neutral government programs. Can you put up quote number 2, please? Specifically saying that we have repeatedly held that the Establishment Clause is not offended when religious observers and organizations benefit from neutral government programs. So that is framed in a very wide way. And as Andrew was saying, the footnote in Trinity Lutheran sort of says, well, this only pertains to this one situation. Well, here we're saying, actually, no, it pertains much more broadly. There's a universal principle here, and it's fairly broad. And here it is, that the Establishment Clause is not offended when religious observers and organizations benefit from neutral religious programs, neutral government programs. However, the no-aid clause in the Montana Constitution has been interpreted more broadly than the Establishment Clause. It prohibits any aid to religious schools, even if it's indirect aid, such as under this case. He then asks whether the Free Exercise Clause prevents the application of the no-aid clause to the tax credit program. He says that in Trinity Lutheran required that disqualifying an otherwise eligible recipient from a public benefit solely because of the religious character imposes a penalty on free exercise that triggers strict scrutiny. Strict scrutiny means it's a very challenging review of the government's intent and the law. In other words, benefits cannot be denied solely because of the religious status of the organization. And in this case, he sort of analogizes the situation to say that Montana's no-aid clause bars religious schools from public benefits solely because of the religious character of these schools. And the same holds true for parents that want to send their children to these religious schools. And is this true? Is this only about religious status? Well, we're going to discuss that further, and I'm sure my colleague Nick will touch on that more. Here he says the prohibition singles out schools based on their religious character. So this is a disallowable discrimination based on religious status. Now, Montana argued that the prohibition was instead based on the religious use of funds, that is, for religious education. And Chief Justice Roberts dismissed this argument, saying that the Montana Supreme Court decided this solely based on status, not on use of funds. This is a really important aspect that we'll touch on more. He further says that the application of the no-aid clause was impermissible under the Free Exercise Clause. So it was the application of the no-aid clause which was problematic here. That says that to be eligible, schools must divorce themselves of their religious character, and conditioning benefits in this way is impermissible and as indirect coercion that punishes the free exercise of religion. Next, the court distinguishes this case from a previous case from 2004 called Locke v. Davey, a decision that allowed Washington State to exclude scholarships to obtain a theology degree from a post-secondary scholarship program. So Locke is distinguished in two primary ways. First, Locke prohibited a religious use of funds. So training students to become clergy under this program is not funded, rather than excluding funds for religious programs more broadly. In other words, the funds could be used at religious schools and programs long as the course of study was not theology in preparation to become clergy. So it was a limited use of funds in comparison to funds not going to a particular place or organizations with a particular status. He also says that Locke invoked a historical interest in not funding the training of clergy, which lays at the core of the Establishment Clause, distinguishing that from this case, from the Espinoza case, where the court looked to whether there was a similar historical interest in denying government funding to religious education. But he took a very, very rigid view of the matter. There were a few examples where religious schools were supported. These were contested by Justice Breyer in his dissent, but Justice Roberts indicates that that there was no consistent early tradition, and that was key. There was no consistent early tradition. He discounted evidence regarding the history of no aid clauses in more than 30 states in the mid-19th century because he says that's not early enough to qualify for consistent early tradition. Moreover, those provisions may have been rooted in anti-Catholic animus. So he does not explore that a lot in detail here. However, Justice Alito's concurrence focuses quite a bit on exploring this idea that these provisions are rooted in anti-Catholic animus. Andrew laid some of the groundwork there, but that is contestable at best. Finally, he says that many states today allow such funding of religious schools, even though they have no aid clauses. So it's further evidence of a lack of tradition here. Okay, so given that it's different from Locke v. Davey, this policy, this no aid clause, requires a review of a strict scrutiny standard. To meet this, the government must advance a compelling interest, and the law must be narrowly tailored in pursuit of that interest. Montana asserted that it sought here to protect the separation of church and state more so than the First Amendment requires. But Chief Justice Roberts dismissed this as not compelling, and that's based on some language in a few previous cases, including Trinity Lutheran, that protecting more so than the Establishment Clause is not a compelling interest. Montana also asserted this provision promotes religious freedom, and this is similar to the position that our organizations laid out in our amicus brief, as Andrew described. It promotes religious freedom by ensuring that taxpayer dollars do not go to religious organizations and that governments do not interfere with religious organizations. Chief Justice Roberts dismissed this view as well, calling it state experimentation that suppresses free exercise. He says that if religious groups don't want this interference, they can simply decline the funding. And moreover, here it's especially inappropriate because it also affects families who have the right to direct the religious upbringing of their children. He seems to indicate that the rights are impeded if they are unable to get benefits because they attend a religious school rather than a secular one. Their First Amendment rights. And this argument is pretty unique. It raises a number of concerning questions that some of the dissents explore in greater detail. Finally, Montana says that the clause helps ensure support for public education is not diverted to private schools, but Chief Justice Roberts says that the prohibition is too narrow. It does not restrict non-religious private schools, and therefore it does not meet the strict scrutiny standard. It's not narrowly tailored. Finally, the court wrangles with some of the procedural sloppiness of this case, as Andrew talked about briefly. I'm not going to go into great detail here, except to say that Roberts said that the Montana Supreme Court's legal error was to apply their no aid clause to the program, which violated the free exercise clause of the US Constitution. And therefore, its decision was invalid, even though it left religious schools and non-religious private schools equal in the same place, as neither of them is getting the state funding. In other words, Montana Supreme Court was not permitted to apply Montana law because it was discriminatory against religion, even if the outcome itself was constitutionally allowable. Instead, the Montana court should have realized the no aid provision was not allowable in the first place, and therefore not terminated the tax credit program. And I'm going to editorialize a bit and say that normally judges interpret laws with what is called judicial restraint, meaning that they don't strike down laws or decide decisions based on the US Constitution unless necessary. What we see here is very much the opposite of that, it often called judicial activism. Instead of accepting that the Montana Supreme Court applied their state law in such a way as to result in an outcome that was constitutionally allowable, that is, religious schools and private non-religious schools treated equally, The court reached in to scrutinize how the Montana Supreme Court made their decision at every step in order to allow them to, in effect, strike down the Montana no-aid clause through this decision that they normally could not do so through. And the dissents, each of them called them out on this, especially those of Justice Ginsburg and Justice Sotomayor. Could you please put up quote number 13? This is sort of two parts here. Too many characters fit in one quote. But this is Justice Sotomayor, who said, "Indeed, it appears the court has declared that once Montana created a tax subsidy, it forfeited the right to eliminate it if doing so would harm religion. This is a remarkable result, all the more so because the court strains to reach it." So the court is straining to sort of arrive at this result where basically, Montana is not allowed to eliminate a tax subsidy that if it would harm religion. Each of those two dissents also addressed the question of this issue not properly being before the court in violation of Article 3, often what we call concerns around standing. So this is especially true in Justice Sotomayor's dissent. So let me see how much time. I have a few minutes, so I'll go through a few of the concurrences. I know Nick is going to talk about Justice Thomas's concurrence quite a bit, so I'll just say briefly that as he has in previous cases, Justice Thomas indicated that he does not believe the Establishment Clause only applies to Congress, not to states. States are free to establish religions if they want to. Moreover, the government is free to favor religion, just not disfavor it. So the court's entire Establishment Clause jurisprudence is basically incorrect. He says the separation of religion and government is rooted in anti-religious hostility, and the government's enforcement thereof might be anti-religious. So, I'm sure Nick will explore that more. It's pretty radical. Justice Alito analogized from another case called Ramos v. Louisiana about non-unanimous jury verdicts, indicating that although he dissented, the court decided that the original racist intent of the law meant that the law was unconstitutional, even though the state readopted the law years later. Well, basically, his concurrence focuses mostly on a long historical analysis of the origin of the no-aid clauses, portraying them as being motivated by primarily, if not fully, by anti-Catholic animus back when they were passed and even today, and therefore disallowable. This is supported entirely by reference to journals and other articles which were not entered into the record nor cross-examined and taken out of context. So it's pretty interesting. I think Andrew would probably be better able to address some of this, so hopefully we'll get into it in the Q&A part of the history of these. And then Justice Gorsuch writes to indicate that the division between religious use and religious status is largely illusory. He would require the government to treat religious uses and actions equally to secular uses and actions and programs, seeking to protect the exercise of religious beliefs by requiring a strict scrutiny analysis. Now, Justice Gorsuch doesn't point out that this argument is directly contrary to the holding in Employment Division v. Smith, which ruled that religious exercise could be constrained by neutral laws of general applicability. In fact, he favorably cited Sherbert v. Werner, which was overruled by Smith. However, he doesn't grapple with the problems that this approach identified in Smith, that is, it would make the professed doctrines of religious belief superior to the law of the land, and in effect permit every citizen to become a law unto himself. So those are a few of the concurrences. We can get to the dissents, but they mostly focused on the fact that this case should never have been before the court in the first place, and it lacked, it was improperly granted, improperly decided on a different issue than the petitioners originally brought. And Justice Breyer mostly focuses on asking for a more flexible analysis involving contextual, case-by-case contextual analysis of establishment and free exercise instead of this hard rule. I'll end there. I'm sure we'll get to some of these in the questions and pass it along to Nick.
Hi. Oh, well, thank you to both Andrew and Alison there, leaving me with the fun part, the depressing part, probably a little bit of both. I mean, anybody who knows me knows I'll always take the opportunity to preach apocalyptic doom. we were expecting this decision on Tuesday. I think most people will agree, especially after oral arguments. We thought the court was going to come down this way. It doesn't alter how much it hurt. And the potential impact is just massive. So when we're looking at what the impact of this is, on one hand, you can draw what is a definite impact, which is actually somewhat narrow. And if we can throw up quote 1 again would be great, please. From Chief Justice Roberts' opinion, where he states that a state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious. So that's the absolute bottom line of the decision here. It's going to impact a fair number of states, states which have the no-aid clauses that Andrew was talking about, and who currently don't permit religious schools to access those. It's unclear exactly how many of the no-aid provisions will have to be struck down on this. I believe, and Alison just mentioned to me, I think it's 14 states currently don't allow religious schools on it. How many of those will be struck down is uncertain, because some of them, for example, Michigan, has a ban not just on state money going to religious schools, but on state money going to any public private education on this. In theory, Michigan's constitutional provision can stand on that basis because it's not discriminating against religion. However, in a deeper way, and with the use of history in this case, will they go back and say that Michigan's amendment, although it doesn't specifically mention religion, was intended to disagree against religious schools? Will they try and claim that because the overwhelming majority of private schools are religious, that having this is it's a backdoor way of discriminating against religion? The bottom line is we just don't know. And that's one of the huge dangers of this case, is it leaves things so open that a whole parade of horribles can come from this case, and we just simply don't know where exactly they're going. So if you can pull up for me quote number 18 would be great, because this to me is one of the very interesting results of this case. This obviously is the beginning of the First Amendment. I always maintain possibly the single most important paragraph written in the history of the world. That may be an exaggeration, but it's fundamental importance. If we just look at the religion part here, the majority opinion, the concurrences, and the philosophy of this conservative-leaning court has been one of they call textualism, that it's the language is of critical importance. What do the words mean? And what we're seeing on this is a refusal to apply that where they don't want to apply it. So if you look at the second half, prohibiting the free exercise thereof. Prohibiting is actually a very meaningful word in this. And they've taken it from saying, on the one hand, yeah, that you can't, when it comes to free exercise, prohibiting doesn't mean banning it. It actually means doing anything that makes it in any way more difficult to exercise your religion. And I'm okay in some situations with that as a definition. But if you have a really broad interpretation of what the word prohibiting means, you also need to have a very broad interpretation of the other half, what respecting an establishment of religion means. And if you go through Thomas's concurrence, and in fact, the whole ethos running behind the majority opinion and the concurrences, it's that establishment is a really narrow thing. It doesn't mean favoring religion. It doesn't mean endorsing religion. What it means is, according to the majority, an establishment of religion is the law specifically saying this is the religion of the United States, whether that's Christianity, whether that's Catholicism, whether it's Southern Baptist. So what we're seeing in the result of this, it's been a move all through this current court, is to downplay a very narrow view of the Establishment Clause and an incredibly broad view on what the Free Exercise Clause means. Where else is this going to have an impact? And this is where we start getting more into you're reading the tea leaves on this, but I think with this court, we have every right to be concerned on that. Standing, the matter of standing here is frankly outrageous. I lost a case in the last couple of weeks because it was ruled that CFI did not have standing on this because we were not injured. As Andrew mentioned, this case should have been dismissed based on standing. When the Montana Supreme Court said there is no longer a program, that rules out anyone being discriminated against. No religion was discriminated against in the voucher program because there was no more voucher program. And that it ties into accepting that is a sign that the Supreme Court wanted to rule on this case. They wanted to decide this about the Constitution when they didn't have to. They could have simply turned away and said, there is no controversy here anymore. So it's a problem we're in. And moreover, they didn't just decide it, because again, if they had deciding this, they're meant to decide in the narrowest way possible. And that's simply saying that, yes, in this case, there isn't discrimination because there's no longer a program. Instead, what they ruled is that not only did the Montana state constitution violate the federal constitution, which they didn't have to rule on, they then defined how Montana has to solve that problem. Normally, they will simply tell the state, this is unconstitutional, go away and do it in a way that is constitutional. For example, don't have a voucher program. They wanted to go further here, and they did something which the court simply is not meant to do. They said, you, Montana, are unconstitutional, and here is the way that you have to cure that unconstitutionality. You have to reimpose the program. I don't know how far that's going to go. Does it only apply to programs that were immediately there? Does it apply to zombie programs from 50, 60 years ago? Can the Supreme Court demand that a state reintroduces a program? The problem here is that we have never seen this. We simply don't know how far they can go on this. Another potential impact on this, and if we look at a quote from the Chief Justice on this as well, and I apologize for the delay here. When the Chief Justice talks about, yes, it's quote number 6. This case also expressly turns expressly on religious status and not religious use. So the chief here is trying to have his cake and eat it, sort of saying that, yes, we can see some situations where the money is going specifically to hold religious services or something. But here, you're just saying because it's a religious school, you can't do that because that's status. This is a distinction without meaning. This is going to blow the doors open for everyone to claim its religious status rather than religious use. Even Justices Thomas and Gorsuch in their concurrence recognized this is just it's a BS distinction. And so we're going to come totally onto just religious, everything will be religious status on this. And where in particular this really bugs me, and if we can throw quote 5 up here, is that Chief Justice Roberts admitted in his own opinion that parents chose these schools because they were religious. Petitioners choose the school in large part because it teaches the same Christian values that they teach at home. If that's the case, if people are choosing it because of the religious element, then how can this be status rather than use? It just doesn't make sense. Another potentially very scary part of this, and I'll try to wrap up with this one more, is the definition of religious freedom that's put out in this. As Andrew mentioned, the brief we submitted that FFRF wrote very ably focused in on the idea that religious freedom is at stake here, that we have a religious freedom not to fund someone else's religion. The court completely ignored that. They have ignored that concept. They talk about the religious freedom of the school and the religious freedom of the students. At no time do they talk about the religious freedom of the taxpayer. And again, this is part of a trend to ignore the role of the non-religious here, that religious freedom is all about allowing a religious person to do what they want, but doesn't include allowing a non-religious person not to support that financially. So we get into what Justice Thomas writes, and what Thomas on Establishment Clause cases has always been on the crazy side of things. And unfortunately now he's got Justice Gorsuch supporting him, which is very disturbing, because that's 2 out of 9 of the Supreme Court for the following proposition. And if you can throw up quote 9, please. Justice Thomas, supported by Justice Gorsuch, has written into the law that the modern but erroneous view of the Establishment Clause, under the modern but erroneous view of the Establishment Clause, the government must treat all religions equally and treat religion equal to non-religion. That's something we've depended on, this idea that non-religion has the same rights as religion. 2 out of 9 Supreme Court justices are open that they don't believe that anymore. I think it's pretty clear Justice Alito does not believe that. So that's 3 out of 9. So we are relying on Justice Kavanaugh and Justice Roberts, Chief Justice Roberts, to support the idea that non-religion is of value. I am incredibly scared that's going to be taken out. Finally, I want to talk a little on this idea of doing history, that the Supreme Court and these opinions include all this talk about history on it. And I really will defer to Andrew on this, because he has a wonderful law review article that came out recently in the Northeastern University School of Law Law Review, which is called Bad History, Bad Opinions. I really want as many people as possible to read that, because the Supreme Court believes that if something is a historical practice, they can rule on it and approve it, but they don't accept that history is not one single universally accepted fact. Different people have different histories. As we can see with the whole Confederate statue situation at the moment, how we look at history very much depends on where we're from. As Andrew mentioned, New Jersey had a no-aid clause going back to 1776, and yet we see Justice Alito claiming these no-aid clauses were a post-Civil War implementation to oppress Catholics. When people think they can control history and define history, and that's what both the conservative majority and the religious right groups like the Becket Fund have tried to do, only their view of history is what they put forward. We need to recognize that history is adversarial, that history comes from different people's viewpoints and isn't simply a matter of opening a book and saying, this is what happened. So I apologize for bouncing around from place to place on that, but I think this case is going to have massive impact in a lot of different areas, and I think a lot of that's going to come up when we talk about the various questions.
Thanks so much, Nick. Actually, I'll like to focus right on that point. I have a question for both of you. You know, this case specifically is about tax credits, and I would say, of course, it applies to vouchers as well. But does being about tax credits and vouchers make any difference here? The ruling is about discrimination based on religious status, but so under that framework, does it matter what other areas of the law is expanded to? This concept that the government funds private X, then it must fund religious X.
Yeah, I mean, I think this could have far-reaching implications. I mean, if you want to get the farther we get away in time from Supreme Court decisions, the more they get boiled down to oversimplified essentials. And where I see that happening in this case is Chief Justice Roberts redefined state-church separation as discrimination. So I redefined state-church separation as discrimination. And he does this by focusing only on Christians. So in other words, he manages this redefinition by ignoring and excluding minorities. If only there were a word for what that actually does. I mean, so this is a big claim, and I think it's important that everybody understands how he did it, because it is going to apply to other areas. So Montana and FFRF and CFI and American Atheists, we argued that those no-aid clauses are necessary for religious freedom. And what Roberts wrote in response to that, Sam, if you can put up quote 7, he wrote that we do not see how the no-aid provision promotes religious freedoms. And then he goes on to focus on specific school examples, and he says, Montana's argument is especially unconvincing because the infringement of religious liberty here broadly affects religious schools and adherents. So he's talking about Christian parents and Christian schools, and only about Christian parents and Christian schools, nobody else. So religious liberty was imperiled in this case, and it was trampled by these Christian nationalist judges because they only considered the Christian parents and the Christian schools as possessing the right to religious freedom. So they failed miserably to correctly understand who exactly possesses that right. The religious liberty right at issue in this case lay not with the Christian parents and religious schools, instead with every single taxpayer. Because that taxing power is inherently coercive, because to tax a citizen and then turn around and give that money to churches is sinful and tyrannical. So that was the religious freedom at issue here, the right of the citizens not to be taxed to support religion. And I don't see a real limit on that. I mean, I think we'll argue it, certainly, but I don't see where you draw a line saying that this would only apply to vouchers, right? Because they failed to apply that right where it actually truly lay.
Yeah.
Nick will disagree with me.
I wish I could. I genuinely wish I could disagree with you, but for once, you're right, Andrew. What the court seems to do here is what liberals are always accused of doing, which is ignoring that there isn't a money tree. The money comes from somewhere. According to Chief Justice Roberts' opinion here, it doesn't matter where this money comes from. We can ignore the fact that there are actual individual people who are paying this money and who have rights. He starts his rights analysis from the money is in the treasury, where does that money go to? Mm-hmm. And I mean, honestly, I think Sotomayor hit this fantastically. If we can put up quote 16, please, Sam. She just got this absolutely right when the court further suggests that by abstaining from funding religious activity, the state is suppressing and penalizing religious activity.
Right.
That's never been the law before. That's never been what the Supreme Court has ruled. we've redefined freedom. Freedom is no longer, the freedom of no religion is no longer the ability to worship as you wish. It's the right to be paid money from the state, and that doesn't stop with vouchers. That goes everywhere.
Yeah. Well, even if we just restrain it to vouchers, this administration has been working very hard to both repeal the little protections that exist for vouchers in different areas of the government, and also turn more social services programs into voucherized programs. For example, we have vouchers in things like housing. So how does that apply here? Are people going to be forced to get housing at religious places that might not, might not want to serve them? They might just have no options, or will they be forced to endure, basically be forced to sit through church services in order to participate in those housing services? That's sort of the protections that the administration is trying to from voucher programs. There's also been efforts, for example, to turn Medicare into a voucher program, which would also have a big impact here, as well as programs like Social Security, disaster assistance, veterans care. So this is, as voucherization efforts sort of spread, I think this will have an even larger impact over time.
Absolutely on that. I always maintain that I did an interview just before this, and I made the comment that I'll make again, is that anytime you get a court decision, bottom line rule, a Supreme Court decision that advances religious privilege is one that's harmful to the LGBT community. That's just a bottom line rule, because it's a license to discriminate. The impact of this case, if more and more children are funneled into, if more queer children are funneled into schools that tell them they're evil, tell them that they are sinful, the impact on that community is incredibly problematic.
Yeah. And it's not just LGBT people, I would say, either. I mean, it definitely affects secular people as well. We've had cases where, for example, a homeless man was forced to obtain shelter, at a Catholic service provider, and forced to engage in religious activities, basically, in order to stay there, that he did not want to do. And that's, if these programs become, more voucherized and protections are stripped away, we're going to see that more and more. In order to get essential social services, you're going to be subjected to these religious sort of requirements.
Yeah, I mean, we ought to spend a little bit of time too specifically on the voucher. I mean, there were so many myths about vouchers that were just scattered throughout the majority opinion and the concurrences. I mean, it was so frustrating to read and to know what the data actually says about vouchers and the way they were talking about them. I mean, so for instance, school vouchers don't benefit low-income students attending failing public schools. There's this myth that they save the kids, right? Voucher schemes benefit private schools, not students. So when they were implemented here in Wisconsin, 75% of the voucher recipients were already attending private schools. So they're helping rich white kids basically go to school already. Same thing happened in Georgia when they enacted their neo-voucher scheme in 2008. There was a report that found that it increased private school enrollment by 1/3 of 1%. Everybody was already in private school who was taking advantage of these vouchers. I mean, the American public is staunchly opposed to vouchers. I think it's like 70% typically or higher of the country always says they don't want vouchers. We know that vouchers don't work. Study after study shows this. In Milwaukee, the oldest voucher program, voucher school students consistently perform worse than public school student on state exams. Fraud and abuse are rampant in voucher schools. This is also something that we pointed out in our brief, pointing out that, by the way, you're going to bring down a lot of government regulation on religious schools because of this. And we've talked a little bit about discrimination here, and the majority and Alito in particular really relied on the idea of discrimination to destroy a lot of state church separation here. But discrimination is okay at voucher schools. They're religious, and they discriminate against special needs kids. They discriminate along racial lines. They discriminate against LGBTQ kids, and that it gives lie to the idea of a choice as the motivating ethos of vouchers. Choice is BS. It's only a choice if you are neurotypical, cis, hetero, and white. That's the only choice you have. And we can even go farther and point out that vouchers themselves are rooted in discrimination and segregation.
Yeah.
So I mean, they arose as an attempt to keep the schools segregated. Their segregationists would rather destroy public schools and send their kids to private schools than integrate. So if we're talking about taint from discrimination, vouchers have got to die too. But you're never going to get Alito and Roberts and Kavanaugh to agree to something like that because they're hypocrites.
And I think we're going to see that hypocrisy coming up in the ministerial exception cases that the court is about to rule on, that a Catholic school who fired a teacher because she had breast cancer is claiming immunity from any kind of review on that, because they claim all of their teachers are the position itself is so religious that it's a ministerial position and the government can't look into it. So on the one hand, religious school teachers are so religious that they have to be allowed to ignore all anti-discrimination law. But on the other hand, religious schools aren't religious, really. It's just status, not use. And so they should be entitled to taxpayer money. We're going to see a staggering level of hypocrisy in these decisions.
This was actually pointed out by Justice Breyer in quote number 12, which is sort of a two-part quote. The subsidy petitioner's demand would go to pay for, among other things, the salaries of teachers and administrators who have been found, in at least some circumstances, to so personify the beliefs of churches that employ them that they are quite literally ministers within the meaning of the First Amendment. So this is Justice Breyer quoting another case called Hosanna Tabor. And so, here we're saying these are so religious, these people personify their religious organizations and their beliefs, and at the same time, this is not a religious use of money. Like education, this religious education is not a religious use of money. It's an amazing contradiction.
Yeah.
So let me ask you both, after this decision, does the no-aid clause, is it applicable in any circumstance? Does it exist, these no-aid clauses across the country? Can they be applied in a constitutionally allowable manner, or are they struck down? The court just didn't have the wherewithal to say so?
Yeah, I mean, I think that's kind of the big question, and it's a hard one to answer. I mean, it's simpler to talk about in maybe broader terms. I mean, it's at its most basic level. This decision redefines state-church relation. Religion wants all of the benefits of state-church separation and none of the burdens. So, under our law, religion is different. Under our constitutional order, it's a different beast. And it was kind of these state and church were these like two wary animals circling each other, staying out of each other's territories. But now it's better to think of one animal, religion, as a parasite. There was this sort of hands-off, you do your thing, I'll do mine approach. But now, the religion would claim state-church separation as a way to keep special privileges, right? So one of the special privileges was the Hosanna Tabor decision we were just talking about, right? That was a 9-0 decision saying that churches should be able to hire whoever they want and discriminate even when they're hiring their ministers. And I think most people would probably agree with that. The problem is when they start defining ministers as anybody who works for them, even in a secular capacity, like a janitor, for instance, then you're running into problems. And as Nick said, the Supreme Court's going to address that. Churches are tax exempt, and a lot of them claim that they have a right to that tax exemption rooted in state-church separation. Church autonomy, right? So the court is not going to wade in, a secular court in our system is not going to wade in and decide a splinter group from a church disputing doctrine, they're not going to wade in and deal with anything in terms of internal church disputes, especially regarding doctrine. But now churches have argued and won. Basically, if you treat us differently in a way that we don't like, it's discrimination. If you treat us differently in a way that benefits us, it's because the Constitution requires it. And that, my friends, is religious privilege. Right? So eviscerating the no-aid clauses, whether or not they stand or whatever is left, augments the benefits that churches receive under a separation of state and church and minimizes all the burdens. So, put simply, they wanted and now get special treatment. they have their cake, and now the American taxpayers have to buy it and get to eat it too.
It's kind of, I mean, there's almost a part of me sitting back, sort of cackling. It's like, okay, you've made your bed, now you lie in it. Let's see where this goes. Unfortunately, where it goes is going to be completely disastrous. It is a fundamental change in the relation between church and state. It's also a pretty fundamental change in the relationship between the federal government and state governments.
True.
This is a massive power grab by the federal government. Not something you would traditionally think of as these justices supporting. But there you are. I mean, where we're going to see this come down is we're going to see a state trying to exclude a madrasa from a voucher program. Is that allowed in this? This decision was written not just religious privilege, but it was written as Christian privilege in it.
That's a better statement.
How is it going to be interpreted when it comes to other religions? Because at the moment, it's like the country seems to be okay with Judeo-Christian privilege. The country's a little less happy when it comes to the many other religions that exist. Our friends over at the Satanic Temple are presumably setting up schools as we speak and will be recruiting kids and demanding public money.
Here's a fun one. The Westboro Baptist Church. They probably have more lawyers per capita than any other church out there. Like half that family has a law degree. They have their own law firm that they've founded. They know how to get access to their rights when it comes to fighting the government. If you don't think they're going to start up a school in that house to have the state pay for them to educate their kids, you're crazy.
Yeah. Justice Breyer,
and then you go one stage further, homeschooling. What happens with homeschooling on this? I just don't know.
Justice Breyer asked a few of these sort of thorny questions. There's two I wanted to highlight in particular. One, he asks what happens if qualification requirements for government benefits disallow some religions or favor one religion over another, right? So, and I think that's a really interesting, I mean, that's obviously going to come up. I think it's already going to be a big issue in the Fulton case, right, next term. So how does that play out with this decision?
Go for it, Nick. I mean,
it's going to be, how should it play out? It should play out to be a big, hideous mess on this. How it's going to play out is the court will work out ways of pushing it towards Christianity and away from religions they don't like. We saw that already in I think it was a Nebraska case, a federal case out of Nebraska with a prisoner who wanted the Church of the Flying Spaghetti Monster. And they just turned around and said, no, this doesn't apply because that's not a religion. On the one hand, they say they can't look at what religious beliefs are until they want to say that your religion is not a religion because it suits them. Unfortunately, I think they'll just find ways out of this only applies to Judeo-Christian.
Yeah, I mean, I think what Nick is getting at is this court doesn't seem to be guided by legal principles, as this decision clearly indicates, right? This is very clearly a reverse engineered decision to get at the result. It's mind-bogglingly so, and poorly done, I might add. Not even like well engineered in reverse, and so it. You know, we had, if you guys remember when we were writing this brief together, I had included in there a pretty salty closing about the politicization of the court. And we ended up cutting it in the end. We predicted that the court was going to do this because they were motivated not by legal principle, but by political and religious principle. And I think we were just proven right here.
Yeah. Well, my other question for you, I guess we'll make this last question and go to audience questions, is, okay, so let's say, I don't know, we're in New Jersey or another state. and we have a voucher program that's now required to give money to religion under this ruling, religious schools. But we don't want to do that, and therefore we're going to repeal our program. The legislature, not the courts, the legislature says, you know what, we're going to repeal our program just to make sure that we don't do anything unconstitutional here that violates our Constitution. So what happens? Is that allowable?
Yeah, Sam, put up quote number 1. Both Nick and I are going to want to talk about it, whatever. I mean, I think it's going to be a hard thing to argue, because that is exactly what the Montana Supreme Court did. I mean, the Montana Supreme Court said, look, this program violates the Constitution, and we're not going to leave a program that discriminates against religion. We're going to strike the entire thing down. They got rid of everything.
Yeah.
There was no discrimination because there was no program. There was no differential treatment because there was no treatment at all. And still the Supreme Court waded in here. And so I don't know how you get it. And Nick was talking about this, how far this might mean legislatures have to resurrect programs going back 40 or 50 or 60 years. We don't know what this means. That's going to be a source of litigation. And I can promise you that the Christian nationalist law firms out there are right now scouring all of the past legislation, possible, old, defunct, whatever it is, to bring challenges along. I guarantee it. Every summer intern right now the other groups is doing that.
Yeah. I think this is an example of the absolute hypocrisy in this decision, because I think what you're referring to, Alison, is Roberts talks about how this was the Supreme Court did ignore the legislature, the Montana legislature, which wanted this program and struck the whole thing down. So would it be different if the legislature did it? Not according to this quote. It doesn't say, if the court decides. It says if a state need not do this, but the moment the state decides to do it, it has to include religion. It doesn't matter if it's the legislature later that decide, it's once they've made that decision, you can't discriminate against religious folk on it. So I don't think they'd allow a legislature to do what you're saying. Unfortunately, I'm not sure we have many legislatures that would actually, because of the way states are gerrymandered, I think most legislatures would be more than happy to vote for this kind of program.
Sure, but states cut programs all the time. I mean, that does exist. And, if they can argue that they can't cut programs, any given program, because it doesn't involve, that would somehow not benefit a religious group. I mean, I think the answer in some ways points to, can the state successfully do so without in any way indicating that there's an anti-religious bias, right? Can they do it?
And after Masterpiece,
it's very challenging. And I mean, any record, and this is another problem that actually we're focusing on in a brief we're working on currently. It really ties the free speech rights of lawmakers. Like if I were a lawmaker and I were to sort of say that we don't want to do this because we don't believe this money should be used for religion, it's wrong, religious groups use money to discriminate, etc. Or even worse, I mean, that's pretty mild. But let's say I say something that, some people might not like. You're supposed to be able to do that in the First Amendment. But now, if you have some sort of anti-religious animus associated with your name, are your legislative actions subject to the strict scrutiny? I don't know. It's really challenging.
If I talk about Columbus and say that Columbus had the support of the papacy and brought priests and they would baptize Native Americans before murdering them, that is now, especially according to Thomas and Alito, that is a demonstration of anti-Catholic bias on my part.
Yeah, and remember,
stating a historical fact.
And I mean, that is what happened in Masterpiece. You're right, Nick. I mean, she stated the commissioner at issue stated a clear historical fact about Christianity, and that was viewed as hostile to religion. And remember that in this case, the Montana Supreme Court pointed out, like, the reason we have the no aid clause is because we want unequivocal support for public education. That's why they had it. And they were clear about their reason. It just that it was manifested in this language that they could point to as anti-religious, even though it's not. And so I think your question, Alison, is if they said, we're getting rid of this program because we want unequivocal support for public education, and we're getting rid of all support for private and public vouchers. That would be the way to do it.
Yeah.
But they ignored that here. I mean, Roberts just glosses right over it. So, I mean, it would be a more difficult challenge to bring in the court, because if you're not stating it and you're not pointing to a no aid clause to do it, it's harder for the court to latch onto. But I'm not sure that it would survive still.
Legislative records are rarely that clean. People say things, make statements in campaigns. You know, we're talking about hundreds of people, hundreds of lawmakers across who knows how long.
And you just need one quote.
Right. And the fun part is
that
like you don't, if you tried to do that to uphold an establishment clause challenge and say like, hey, look at this legislative record here, it goes to the purpose. These same judges would say, no, there's too many legislators. We can't tell what the purpose is. We're not going to analyze it.
Look at Trump v. Hawaii, right?
Yeah.
I mean, I can honestly see a case coming up where it's that 95% of private schools are religious, so by cutting, it's almost a disparate impact type notion. That the purpose of cutting private schools was to attack those 95%.
No, and actually, Nick, now that you've said that, you're 100% right. That's exactly what they're going to argue, and I think the lowest number is somewhere in the high 70s in terms of percentage of private schools that are religious. 80% of students that get vouchers go to a private religious school. So
I do have one more question. I was wrong. Okay, let's say this goes back. This goes back to Montana, and they say, you know what? We're not going to continue. We're not going to examine status any longer. We're actually going to apply this as if it were about use, and we're going to say, this is actually what this is meant to prevent is the money going for religious uses, and therefore it is allowable under your construction, Supreme Court, and the program is still struck down.
I'd love to see that. I would love to see the
well, let's be dynamic anyway.
I mean, and it, the go back to the language, shall not make any direct or indirect appropriation ... for any sectarian purpose. I mean, to me, that does speak of uses. Like, what is the purpose behind what you were doing? What are you using the money for? So I think they have a colorable argument for that. And I think the Supreme Court definitely overstepped here. I'd love to see that.
And you want to see how far these the concurrences go towards religious privilege. Alito says that using the term sectarian is anti-religious.
Right. Yeah.
That the word itself is discriminatory.
Coded. Yeah. Hopefully somebody asks about that history, because it's
well, let's get to those. I feel like I've been occupying too much. So Sam, can you pull up one of our questions?
It's actually fine, Alison, because you've been answering a lot of the questions that people have been asking and sending in comments in this little section here. So I'm like crossing them off. So the second ago was, is Montana now required to reinstitute a program that it decided to discontinue? And so it sounds like the answer is,
we don't know. It depends. The best lawyer answer.
Yeah, that's the answer to all the questions.
Right. All the questions are, it depends.
Yep.
And then similarly, I think that you touched it on a little bit, but there was several different questions asking, this was the Supreme Court, so what can we do now to combat this? Is there, in particular, is there a list of states that the constitutional provisions have been nullified? And are there ways to pass state level legislation to combat these? And I think that you pretty much answered that one, but I didn't know if you wanted to expand on it at all.
Sure. Well, let me just say that we, American Atheists, every year does an assessment of state level laws and policies called our State of the Secular States Report, which is at atheist.org/states. So we look at a lot of these church state measures in every state, what it looks like, the law in each state. And we look at things like both no aid clauses and also states that have school voucher programs. And so one of the things we can do potentially is urge states to repeal their school voucher programs. And I think we're going to be doing some alerts and actions around that in the coming days to encourage states to say, well, look at this, this is opening a door that you can't close. So you're better off repealing these. As for other actions, there's always, of course, voting. It's very, very important. And, the president decides who's on the Supreme Court.
Elections matter.
And with that, it's The way you need to target voucher programs now isn't a religious church state way. The way you need to target voucher programs at the moment is these are taking money away from public education wherever those vouchers go.
So that actually was an excellent segue to the next bunch of questions that we, or comments that we got regarding voting. And if we do end up with a different president, is it time to pack the court? It was put in the comments several times in several different places. So is that an actual possibility? What are the chances of that happening?
So Congress decides how many members of the Supreme Court there are and how many members of the federal judiciary there are. So they can decide that. It is not set in the Constitution. It's decided by Congress. So it is something that is possible. They could change the number. They could change it to whatever they want. So is it possible? The answer is yes. Should it be done? That's more of an opinion question. My answer is unequivocally yes. I'll leave it to my colleagues to decide.
I mean, I agree. I mean, I think whatever your solutions are to the country's ills, I mean, I consider myself a progressive. I won't say left or right or a party because we're all nonpartisan organizations here. We're representing nonpartisan organizations. But whatever your solutions are, they have to survive in a judiciary that's been flooded by 200 Trump nominees who care about Christian nationalism more than anything else, and a Supreme Court that is supremely unfriendly to our causes. Even the victories over the last 2 weeks, this should be a big warning sign to everybody about those victories, especially Bostock, which was correctly decided, but left not a hole, a time bomb, in the opinion. So, I mean, whatever you care about, you have to figure out a solution to those. You have to figure out a way that those solutions survive in this judiciary. And the only way to do that is to remake the judiciary.
Alison and I have had this conversation so often, and it's been so much fun. And I, despite the fact I'm the British guy on this, I tend to be the defender of the American system, and that I am always really nervous of things like court packing because of the precedent that it sets and everything. But like Alison and Andrew, I have come to the opinion that the federal court system is fundamentally broken and has been broken because it became politicized. Is the solution packing it? I don't know. I'd still like to think that there's another solution, but I can't think of one. So I'm the worst person in the world now to turn around and say no packing, because I really can't think of an alternative. And go Packers.
Well, and let's say one more thing too. The federal court system is like grossly overworked right now. You could double the size of the federal judiciary, and it would still take them a long time to catch up with all of the backlog. So
that's actually needed. I mean, regardless of anything else,
federal
exactly. Double it, and that would be fulfilling a need of the country. So.
Yeah, and it hasn't been. They haven't been able to do it because it's been so political. Yeah. So anyway.
And in a similar sort of, lots of people asking this question. Does this mean, or how would we go about, or is there room for us in this space now to tax the churches if they are accepting public money? I think I already know your answer, but it's been asked a lot.
I mean, sure, but we don't have a political establishment willing to do that, and I don't even if they did some amazing way, I don't think the court would allow that. So. I don't know. My short answer is that's not realistic.
I think it's also not realistic. I mean, it goes back to how we were talking about this reconceptualizing state-church relations in religion gets all of the benefits and none of the burdens, right? And taxing them, there's a line somewhere in the jurisprudence that, you know, the power to tax is the power to destroy. Yeah. And so this court almost certainly would say that churches have a right to tax exemption, whereas before it's always been considered and explicitly stated by the Supreme Court that tax exemption is a privilege. This court would say that it's a right if that challenge ever came up, for sure.
So we don't want to do that right now.
So fix the courts first.
Yeah, ain't gonna happen. Wish it was, ain't gonna happen. I think what we need to start looking at is to play around the edges on this, and we need to start pushing for equality in tax exemption on this. We're not going to get rid of the religious tax exemption, but let's work on having them file the same forms that we all have to file every year on this.
So increasing transparency, at least.
Yeah.
Great start.
And there's several people, I think that you touched on this, who've asked about what happens when Satanic Temple asks for funds, or Islamic schools ask for funds, or other religious groups, Wiccans and so on, that folks won't want to give funds to.
Yeah. I mean, what if they create an atheist school that is like specifically anti-religious? I wonder, and demands funds. Anyway.
Yeah, we and it's something we need to be a little bit careful on that, because there's always been the argument by the religious folk that secular humanism is a religion and evolution is one of the tenets of secular humanism, and so you shouldn't be teaching evolution in public schools. It's an incredibly bogus argument. I just don't like.
Stupid argument too. I don't use that word.
I mean, if you've seen,
it really is
the case in DC that someone brought at the moment, challenging the Black Lives Matter painting on the street because it's religious. I mean, this is crazy, but unfortunately, it seems like we have a federal court system that's willing to. Honestly, go back 10 years. Would any of us have thought the idea that signing a paper saying you wanted an exemption would be considered by this court to be a burden on religion? And we're about to get a decision that turns around and explicitly says signing a piece of paper is a religious burden.
It's interesting you talk about the religious aspect. Actually, one thing struck me in Justice Alito's concurrence, where he says, the common school movement did not aim to establish a system that was scrupulously neutral on matters of religion. And then in parentheses, in a country like ours, that would have been exceedingly difficult, if not impossible. So he firmly does not believe that our schools are neutral on religion.
Yeah, I hated that parenthetical. Also, just part and parcel to his bogus, entirely cherry-picked history. I mean, one of the worst historical recitations I've seen in a court case ever. And that is, especially coming from Alito, who wrote Bladensburg, really saying something. I mean, it's remarkable.
Yeah.
Yeah, I maintain actually on this that I've read a lot of bad Supreme Court decisions. I mean, I've read Plessy versus Ferguson and Dred Scott, but the Gorsuch concurrence is quite possibly the most stupid thing I have seen a Supreme Court justice put on paper. It's just frankly ridiculous.
I felt that way about the per curiam that came down in April about the Wisconsin election. I thought that was one of the things I've ever seen, and that made me think it was Alito too. But he was confirmed. He was confirmed on my 24th birthday, so I have a special low.
Oh, you're a youngster.
Anyway.
All right, Sam. I think we maybe have time for one more.
Yeah, you guys have pretty much gone through all of the questions. The one that's sort of just an open question at the end is, does this open the door for us to be in the U.S. an open theocracy? And how concerned should we be about that?
Well, I think it depends on how you define a theocracy. I mean, can they tax taxpayers and give the money to religion? Yeah, right. I don't know the answer to that because I'm not quite sure how you define a theocracy, I guess I would say. I don't know. What do you two think?
I mean, I do think that is problematic in the question, but I don't think it's too alarmist to talk about that. And I'm going to use this as a chance to talk about why, the court using history to determine law and how, they've done this a lot in recent opinions, especially involving the separation of state and church, and using it to get away from the clear history and the clear legal principle of separation of state and church. So, I mean, it's this terrible approach, and it's easy to see why conservatives use it, because legal principles are clear and simple and rigid, right? So the separation of state and church is clear. You could not have a theocracy where you have a separation of state and church. or we should at least say it's clear enough that we all understand it to mean that the government can't fund religious education. History, as Nick was saying, is not clear. And in fact, it's like incredibly malleable. You can emphasize and highlight some facts and ignore and entirely omit others. And you really see that in this opinion, especially in Alito's concurring opinion, where he talks about the anti-Catholic bias of no-aid clauses in the history. I mean, this is a really complicated subject, and if you want to read an excellent scholar on it, Professor Stephen K. Green of Willamette Law School has written extensively on this. A couple law review articles. He wrote the amicus brief, I think it was Baptist Joint Committee, I think. And he put it this way: the impulse toward non-sectarian public education was based on noble Republican ideals. And then it was later hijacked. Nativist groups later hijacked the no funding principle for their bigoted aims. And so, you get all this really bad history in Alito's opinion, and it was crucial to the way the court decided it. So here are a few things. The court mentions all this anti-Catholicism, and here are a few things they never mention. Blaine, who is, supposedly this anti-Catholic bigot. This is why we get the Blaine amendments. His mom was Catholic. Many American Catholics during the 1870s actually wanted these funding prohibitions that were provided by the no-aid clause. The Catholic Church in America at that time attempted to grab a chunk of public funds for its own school systems and even sought a constitutional amendment for doing so. So it's not like this was just happening in a vacuum. The Catholic Church was actively trying to get its hands on public funds. And, you have Catholic scholars, Sister Mary Klinkhammer, writing in the Catholic Historical Review as an associate professor at the Catholic University of America, concluding that the Blaine Amendment was suggested for purely political reasons. So not put up as this anti-Catholic terrible thing. So, the history is absolutely warped and tortured to reverse engineer the result. And that is now the norm. That's why I was writing that law review article that Nick was talking about earlier. And I think we are seeing that more and more, not less and less. And so I think we are certainly slouching towards theocracy, and this approach is hurrying us along.
Yeah, to look at the history on it, what's dangerous as well is even when they put in fair history, even if this was a broad view of it, the next case cites to one sentence or one clause out of it, and no one refers back. Are we going towards theocracy? In some ways that's way back. The except for theocracy we took quite a while ago. It's not going to be blatant. We're not going to have replace the president with an Ayatollah. But look at what Justice Thomas is saying. He's saying that the law can specifically discriminate in favor of religion and discriminate in favor of particular religions. We know that's going to be Christianity in the US. If that's not what is in effect a theocracy, I don't know what is.
And on that cheery note,
well, I can give a cheery note to end because I do think we should. I've been doing this for a decade now, state church litigation, and I have said from very, very early on, it has become clear to me that we are not going to win this fight in the courts. We are going to win it with demographics.
That's true,
right? And that is absolutely true today. What you are seeing is the Christian nationalists, especially those on the Supreme Court, they are raging against the dying of their privilege, right? They can read the demographic studies as well as we can. They're going to church on Sunday mornings, well, at least before COVID they were, and they can look out and instead of seeing young smiling faces, it's empty pews, okay? They know what's coming and they're doing their damnedest before we get there to legislate and solidify that privilege in the law. And this was a big step towards doing that. So they're doing a ton of damage right now, but none of it, despite how far we've slouched along the road to theocracy, is to the point where we can't undo it, right? It's going to be a lot of work, but it's all still, we can still absolutely recover from this. I firmly know that to be true. So even though this was a terrible, terrible week, we will get there in the end. We will win.
Yeah.
Because we're right.
Register and vote. That's the end
Amen.
of Andrew's TED Talk.
Amen. Thank you for coming to my soapbox.
So we get a lot of excellent positive feedback in the comments for you all. And I just wanted to thank you again on behalf of everybody who's been joining us for being here and sharing your opinions and your insights and educating a bunch of folks on this topic. Going to mention that this recording will be available. It was being streamed to YouTube and Facebook and Twitter, so you can find it there. If you missed anything, if you had to look away for a minute or miss something that was said, you can definitely go back and watch it again. And thanks again. I don't know if you guys have any last words that you want to say before we sign off.
Thanks so much for tuning in and hosting this. Really appreciate it.
Thank you so much.